Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. I recently caught up with the folks at e-Immigration who shared a big announcement. Hot off the presses. Have you heard? E-Immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. What to talk about in immigration news this week? There is a lot. We all know, of course, that the big bill thing passed Congress and that President Trump signed it. Heads up to everyone, there are some significant fee increases in that bill that are already in effect, even if EOIR has not updated its portal to so reflect. Be very careful with your motions, appeals, and all things. Read all of the practice advisories that are out there listing out what the new fees are. It is very clear Congress is trying to prevent immigration filings by increasing fees. And they've got that bill passed, so here we are. In other news, Acting Director of EOIR, Ms. Owens, issued an OPPM, issued on July 3rd, 2025, that talks about how the BIA does not have a prior panel precedent rule per se, and that therefore there do exist conflicts between BIA decisions that have not been resolved by the en banc BIA, but that every time the BIA publishes, it's actually essentially going en banc because all BIA members have to agree. Something that Judge Science brought up in our interview a couple of weeks ago, and that in part explains why the Trump administration would fire lots of BIA members, so it would be easier, right, for the BIA to issue precedential decisions, as seems to be occurring multiple times on a weekly basis. But anyway, given that, the BIA cites to two such potentially conflicting decisions that obviously are on the chopping block. They point to matter of Avetisian in the administrative closure context and matter of ARCG, which protects certain victims of domestic violence. The BIA has begun what will surely be resolved by a precedential decision, vacating those decisions by either the Attorney General or the BIA, and I'm sure this PM will be cited or at least relied upon somehow. Immigration judges are to already do it. We're also hearing that DHS attorneys have been instructed to expansively apply their legal reasoning for mandatory detention of IWIs. Start crafting your very smart arguments against that. Always looking for the positive, a federal district court judge this week certified a class that essentially prevents the Trump administration from applying its birthright executive order nationwide. We have 5 cases this week, most of them from the Board of Immigration Appeals, and I'm going to get to them in a second, but not before mentioning that the First Circuit amended its non-citizen-friendly ROSA decision that I discussed on episode 255. In doing so, the First Circuit granted and denied Oil's motion for panel rehearing, in part. Therefore, and while it doesn't seem much of it has changed, I suspect that some things that the government didn't like have been shaved off a bit. Give the decision a read, and First Circuit Warriors, cite to the July edition. And here are your 5 cases. Our first of the three from the BIA is matter of EZ, published by the BIA. This case is about, you guessed it, Convention Against Torture Protection, wherein, you guessed it, the BIA is vacating an immigration judge's grant of said protection. In a decision that, you guessed it, the Attorney General discovered and decided to make precedential when it originally was not precedential. By the way, the BIA has published almost every week for the last 3.5 months, and often multiple times. 5 publications actually 6 weeks ago. Let us begin. Mr. Easy is from Russia. An immigration judge found that he hadn't suffered harm that rises to the level of past persecution, and the BIA agreed with that. Mr. Easy was twice detained and interrogated by the KGB's successor organization, the Federal Security Bureau, or FSB, under suspicion of being involved in an extremist organization, but he was never harmed. Mr. Easy testified that the reason for all of this, he thinks, is because he expressed opposition to co-workers about Russia's invasion and war of choice in Ukraine, a war that the BIA calls the, quote, Ukraine-Russia war, end quote. 13 hours of interrogation, though, with some pretty scary prosecution threats, with follow-up harassment and searches. Mr. Easy styles that as a, quote, sustained and systemic effort to target him on account of his political opinion, end quote. But the IJ and the BIA saw and see it more as harassment, particularly as he was never, quote, arrested or tried for any crimes, end quote. So not past persecution to the agency. Nor did the IJ and the BIA believe that any of it was on account of a political opinion, or at least that Mr. Easy didn't so establish. Seems like the agency believes that there was legitimate suspicion that Mr. Easy was involved in some unidentified extremist organization, albeit never prosecuted. Now, some of Mr. Easy's colleagues were actually charged and imprisoned, but even he testified that he didn't know what activities they were doing. Seems like everyone believes that Mr. Easy's anti-Ukraine war opinions were minimal, making them plausibly a tangential basis for the FSB's actions and investigations. So, asylum and withholding denied and affirmed by the BIA. On to the Convention Against Torture grant reversal. Recall, the IJ granted. But apparently the IJ did not, quote, identify any record evidence supporting his findings that the respondent was previously suspected of working with foreign entities and that he would be again in the future, end quote. Which is surprising. I can only imagine the record has some support for a finding so consequential. But even so, the BIA seems to agree that, quote, the respondent may be detained and interrogated upon return from the United States, end quote. But that's not enough. You need to also show that it is more likely than not that what will happen next will rise to the level of torture. The BIA doesn't see it. We're back to the BIA's clear, recent hostility to CAT claims based on imprisonment in foreign jails. You'll hear more about that later this episode. Although the BIA really doesn't say why in this decision, given what I just said above that they agree he'll likely be detained and interrogated, the BIA doesn't go into that much more detail about why the CAT grant was incorrect. The BIA does say, however, that, quote, there is nothing in the country conditions evidence to support the notion that the respondent or any Russian will be subject to detention, much less torture, in Russia for merely having traveled to the United States, end quote. So it was looking to be a pretty consequential quote until that last part where it was very much narrowed on a very narrowly defined claim, if you ask me. That's only talking about people whose claims are based solely on them having traveled to the United States. The BIA doesn't actually say anything about conditions in Russian prisons, though, other than saying that the record is, quote, insufficient, end quote. But, citing the matter of JFF, the BIA took away the protection from Mr. Easy's removal. And that is matter of EZ. Moving on to matter of Gonzalez Jimenez, published by the BIA. This case is about discretion, even when someone isn't convicted of a crime. Mr. Gonzalez Jimenez is from Mexico. He's been here for a long time, and so he applied for non-LPR cancellation of removal and voluntary departure in the alternative. An immigration judge found that Mr. Gonzalez Jimenez failed to establish the requisite hardship to at least one of his U.S. citizen children for cancellation, and that in any event, he didn't warrant either reliefs as a matter of discretion. And it is there, the latter finding, that the BIA affirmed. Discretion is always a balancing test, and while the BIA lists many factors with its case law, let's be honest, it's just about the IJ weighing everything present in a non-citizen's life. Also, though, and without quoting anything, the BIA states, quote, "Where adverse factors are present, the respondent should present offsetting favorable evidence which may require unusual or even outstanding equities to outweigh the negative factors," end quote. Not sure I've seen it said like that before. It seems like the BIA might be sneaking in a new word or words there, but it could be wrong. I don't know all the precedent. Discretionary decisions are reviewed de novo, I believe. Meaning that here the BIA weighed the facts of Mr. Gonzalez Jimenez's life as found by the IJ. He's been here for nearly 20 years, having entered as a teenager, and, quote, has significant family ties, end quote. Good, consistent employment and nice letters of support, it seems. And removal to Mexico will be a big problem for him and his 4 U.S. citizen children, 3 of whom have medical conditions and developmental delays for which they receive treatment in America. But then there's the negative. Quote, "The most significant consideration is the respondent's 2024 arrest in Florida for drunk driving with a high blood alcohol content and with his 10-year-old son in the car," end quote. To the BIA, quoting the Supreme Court in part, quote, "Drunk driving is an extremely dangerous crime that poses a grave danger to the lives and property of others," end quote. Here you've got the young son in the car and a police report that lists Mr. Gonzalez Jimenez drank about 20 beers. Quote, "The quantity of alcohol consumed and the respondent's actions in endangering a child increase the negative impact of his DUI arrest," end quote. So right there, something to distinguish your case from if a DUI arrest comes across your desk. No mention of a DUI conviction here either. Also, the BIA explains, Mr. Gonzalez Jimenez has been dishonest in the past, quote, "repeatedly using false or stolen social security numbers for tax and work eligibility purposes," end quote. I don't know, though. I mean, isn't that negated in part by showing that the guy is going out of his way, criminally even, to pay his taxes? No weight at all for that, BIA? Nothing? Not even tangential or subordinate weight? Then again, it seems that he misrepresented things on his taxes in the past. So there's that. And, quote, "Use of false or stolen social security numbers and providing false information on tax returns are negative considerations that weigh against a favorable exercise of discretion. Presenting a false social security number and false information on tax returns are examples of deceptive conduct that reflect adversely on a non-citizen's character," end quote. Similar to the recent legislation Congress passed and the president signed, and like Elon Musk's presidential sanctioned actions with Doge, what Mr. Gonzalez Jimenez did, quote, "impacts legitimate tax collection efforts and imposes a public cost in efforts to protect personal information," end quote. Plus, it could be criminal, explains the BIA. In response, Mr. Gonzalez Jimenez blamed his accountant. He, after all, does not read or speak English and isn't a tax professional. He, Mr. Gonzalez Jimenez, thought that he was allowed to do these things. And he thought that the social security number was his and said an attorney provided it to him to boot. An immigration judge didn't credit this explanation, so that's a problem for Mr. Gonzalez Jimenez on appeal. But also the BIA explains non-citizens can't just rely on ignorance of the law. Citing to its 2018 decision, matter of Valdez, a BIA decision that no court has yet affirmed to my knowledge, the BIA explains that, quote, "The respondent has a duty to ensure the accuracy of any representation he makes to governmental authorities," end quote. Gonna go off on a tangent here, matter of Valdez was about immigration forms, and has not yet been affirmed by a circuit to my knowledge again. Extending its holding to apply to all government forms, including tax forms, would appear to be a new decision from the BIA. But making that new decision, the BIA explains that, quote, "it was reasonable for the IJ to infer that he knew and assented to their contents," end quote. Check out Ortiz-Boucher in the 11th Circuit, though, guys. Check it out. Surprised the BIA did not distinguish that case, given that these proceedings appear to originate in Florida, and matter of Valdez was very much aware of Ortiz-Boucher. Not only that, but if you're going to blame your accountant, attorney, or other professional to the BIA, quote, "a claim of reasonable reliance on professional advice presupposes that such advice was sought in good faith and that in relying on such advice one is not willfully ignorant," end quote. So the respondent needs to meet the impossible burden of submitting, quote, evidence of the specific advice given and explain why it was reasonable to rely on such advice, end quote. To the BIA, Mr. Gonzalez-Jimenez's vague testimony about all these events did not cut it. So the BIA dismissed the appeal. And that is matter of Gonzalez-Jimenez. Rounding out the BIA, we have matter of SS. No comment on the title. This case is about, you guessed it, Convention Against Torture Protection. The Attorney General has decided to make this once non-precedential decision precedential. Mr. SS has schizophrenia, schizoaffective disorder, depressive type, and major depressive disorder with psychotic symptoms. He's also been hospitalized in the past while detained and described as, quote, actively psychotic with suicide ideations with a plan, end quote. He was appointed counsel in immigration court because an immigration judge did not believe he was competent to represent himself. Seems like he has a criminal record, which I can only imagine is in part due to his mental health issues, and an IJ granted Mr. SS Convention Against Torture Protection from the country of Haiti. It has quickly become debatable how beneficial cat protection is anymore, given the Supreme Court's apparent blessing of the executive's plan to ship cat recipients anywhere except the cat-receiving country with little to no notice. But still, we fight, and preventing return to Haiti at the moment seems worth the fight, if for no other reason, given the findings that Ms. Noem made in, confusingly, terminating TPS for Haiti. The country is in trouble. Relying on quite a bit of evidence, including an expert witness's testimony, the IJ found that the respondent was more likely than not to be detained upon removal to Haiti as a criminal deportee without family available to secure his release. The IJ further found that the respondent faced increased risk of subsequent arrest and detention as a criminal deportee, even after his release into Haiti. But on appeal, the BIA identified a deficiency in the IJ's decision. Quote, the IJ did not determine whether the respondent's detention would more likely than not continue long-term, end quote. Plus, noted the BIA, the expert testified that it was possible that Mr. SS would be quickly released if returned, particularly, quote, upon a family member's payment of a bribe, end quote. And that some criminal detainees have been tortured in prison is insufficient to show that Mr. SS will. For that, the BIA cites to its very recent decision in matter of AAR. Although one wonders how someone can meet their burden under CAT without literally returning and being tortured then. We, the non-citizens bar, seek guidance on this from the BIA, as the BIA publishes so many decisions. Moreover, even assuming arguendo that the respondent is detained long-term upon removal, the BIA concluded upon de novo review that the IJ erred in determining that the conditions of the respondent's detention would constitute torture, that is, conditions in Haitian prisons. On that end, as expected, the BIA circled back to its 2002 decision in matter of JE, a decision involving similar, quote, allegations about the conditions he would face in long-term detention, end quote, in Haiti. And that makes sense given that, again, JE is a BIA decision about Haitian prison conditions. Although might the fact that the expert testifying here is testifying to similar conditions in Haitian prisons 23 years after JE indicate something about the Haitian government's willful blindness to said conditions? The BIA does not say. It does state, however, that just like in matter of JE, the conditions must not simply be a result of insufficient monetary funds, which is what the BIA believes it is. As such, to the BIA, Mr. SS could not show that conditions were, quote, specifically intended to inflict severe pain or suffering, end quote, the standard employed by the BIA in this decision. Importantly here, because apparently the IJ didn't find that Haitian officials are intentionally doing this, but rather that, quote, prison guards and police have the same lack of understanding of mental illness that is widespread among Haitian society, end quote. Plus, there are reports and evidence that support a finding that some deportees receive some services upon their removal to Haiti, although the BIA doesn't mention criminal deportees with schizophrenia. At base, you need more than anecdotal reports of torture to win, explains the BIA. As to Mr. SS's fear of torture if he is released into Haiti, quote, The IJ found that the respondent is vulnerable to being tortured by members of the community because his mental health conditions make it likely that he will exhibit erratic and abnormal behavior. The IJ did not identify each step in a hypothetical chain of events that would lead to the respondent's torture in the community and did not find that each event is more likely than not to occur." End quote. Matter of JFF strikes again. Generalized evidence of gang ties to police in Haiti is insufficient, says the BIA, citing to its very recent decision in matter of MSI. So, the BIA decided to send Mr. SS back to Haiti. Of note. I just cannot get past that discussion, brief as it was, that Mr. SS may be able to bribe his way out of prison to avoid torture. I admit that the BIA didn't totally rely on that, but it mentioned that portion of the expert's testimony for a reason, and the BIA relies on it a bit to cast doubt on the IJ's finding regarding the length of time that Mr. SS will be imprisoned in Haiti. So permit me to read this to you from the Seventh Circuit's 2008 decision, Bossetti v. Mukasey. Quote, "We are appalled that the IJ would rest his decision on the absurd proposition that Mr. Bossetti could evade imprisonment, mistreatment, and possibly death by approaching his jailers and trying to buy his way out. We have said before and underscore here that whether a non-citizen might succeed in escaping persecution or torture through bribery is an irrational and altogether improper consideration in deciding a claim for asylum or other relief." End quote. And that is matter of SS.
Immigration attorneys. Once you've secured a bond, let Gonzalez and Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez and Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez and Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez and Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez and Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. From here on out, it's pretty quick. Just 2 circuit decisions and neither of them very long. The first one is Castejon-Paz and Cerrato-Barahona v. Bondi, published by the Second Circuit on July 8, 2025. This case is about review of withholding of removal type things post-reinstatement of a final order of removal. It's essentially, but not identically, the Riley v. Bondi Supreme Court issue, but it's not happening in the Farrow context. It's happening in the no reasonable fear finding context. So the petitioners here didn't even get into withholding-only proceedings. Ms. Castejon-Paz was ordered removed in 2012 and must have been removed and then unlawfully re-entered because the order was reinstated in 2014. She asserted a fear of persecution to Honduras, which could have placed her in withholding-only proceedings to assert her fear of MS-13 and her abusive ex-husband. But an asylum officer and then an immigration judge found that her fear was not reasonable, and so she shouldn't even get the opportunity to bring her full claim. They didn't see a nexus to a protected ground, even at the far less burdensome reasonable fear stage. Similar with Mr. Cerrato-Barahona, except a 2010 removal order reinstated in 2019, with, of course, a different factual fear basis. Still Honduras, though. Without going through the whole history, the Second Circuit's Bactabai Patel v. Garland decision kind of kicked off the whole legal battle that resolved with Riley at the Supreme Court a couple of weeks ago. Or nearly resolved. There will be other decisions. Under Bactabai Patel, the 30 days to petition for review is jurisdictional, and the clock doesn't start with the no reasonable fear finding, meaning people like the petitioners here were in big trouble for circuit review. But that jurisdictional holding is no longer good law in light of Riley. The 30-day petition for review rule is a claims processing rule that the U.S. government can waive or forfeit. And, quote, here, the government waived application of the 30-day filing rule as to both petitions, end quote. Surely because they didn't assert it believing that the rule was jurisdictional. I can only imagine. But waived it was. And as such, the Second Circuit denied Oil's motion to dismiss the petitions for lack of jurisdiction and ordered briefing on the merits. Perhaps we shall see these cases again on the merits in a few months, precedentially. Perhaps. So technically, it's some sort of win for the non-citizens, meaning congratulations to John E. Jensen and Xavier A. Palacios for the petitioners, respectively. And unsurprisingly, Trina Realmoto and Christian McLeod Ball with Nyla for amicus, as well as just a whole bunch more of very smart people on amicus associates, because this really is about what are we going to do with Riley when it gets to the circuit level. And so these very smart people are also involved, and they probably will be involved in later cases. So congratulations, and thank you to all. And that is Castejon-Paz and Cerrato-Barahona v. Bondi. Our final case is Garcia-Pascual v. Bondi, published by the 8th Circuit on July 7th, 2025. This case is about non-LPR cancellation of removal. And I knew it looked vaguely familiar. Very vaguely. The 8th Circuit dismissed this case for lack of jurisdiction on episode 151. Seems like it did so finding it lacked jurisdiction to determine whether the BIA erred in denying hardship, and so the Supreme Court vacated the 8th Circuit's decision after issuing Wilkinson. Recall on that decision, the Supreme Court explained that circuits do indeed have jurisdiction to determine whether agreed to facts meet the legal definition of exceptional and extremely unusual hardship, although it's deferential review. And so having so reviewed on remand, the 8th Circuit denied the petition for review. The Supreme Court in Wilkinson mentioned that the review is deferential. Whether it's an abuse of discretion or substantial evidence review, or something else, is now being debated a bit amongst the circuits, and the 8th Circuit does not decide what specific deferential standard of review it will apply in these cases going forward. Not yet. Seems like it thinks that the petition needs to be denied, no matter the deferential standard of review. Mr. Garcia-Pascual has 2 U.S. citizen sons, you see. But both the IJ and the BIA deemed the hardship to them, with Mr. Garcia-Pascual removed, lacking. The IJ noted that their father's removal, quote, would likely strain the family financially and would remove a loving, paternal presence in the boys' lives. But the judge noted these difficulties aren't exceptional or unusual in removal cases, end quote. And the boys are doing quite well in America. Surely in part due to Mr. Garcia-Pascual's care. But in the weird world of non-LPR cancellation, that can sometimes cut against a hardship case, as we all know, and as occurred here. The 8th Circuit sees this case as similar to other recent denials of non-LPR cancellation that it has affirmed denial of. And although the boys don't seem to be taking the prospect of their removal well, that's to be expected too, explains the Eighth Circuit. All of this as well despite the fact that actually, the eldest son is not Mr. Garcia-Pascual's biological son, and without the authorization of his biological father, he may not be able to visit Mr. Garcia-Pascual in Mexico, who he considers his father. But that wasn't really raised below, explained the court. Believing the IJ adequately considered all hardships in the aggregate, the Eighth Circuit denied the petition for review. And that is Garcia-Pascual v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.